Namaskar. In today's video, we shall be looking at some of the important judgments for the month of February 2023. From the Code of Civil Procedure 1908, in the case of Shahnawaz and others versus the state of Nagaland, Honorable Supreme Court held that the power under Section 24 of the CPC can be exercised by the High Court even for interstate transfer of a suit, appeal or other proceeding if it is the common High Court for two or more states under Article 231 of the Constitution and both the civil courts, transferor and transferee are subordinate to it. In the case of Sirajuddin versus Zeenat, Honorable Supreme Court set aside an order of Honorable Kerala High Court whereby it had remanded a matter of trial de novo without adverting to the findings of the trial court and without specifying how the findings recorded by the trial court was unjustified. It was observed by the apex court that de novo trial cannot be ordered merely because a particular evidence has not been adduced. If one party has not produced evidence, then adverse inference can be drawn against him, but that is not a ground to remand the matter for fresh trial. In the case of P. Shamila versus Gundlur Mustan, it was held that the court cannot, as a matter of course, allow extension of time for making payment of balance amount of consideration in terms of a decree. The court has to see all the attendant circumstances, including if the vendee has conducted himself in a reasonable manner under the contract of sale. The power under Section 28 of the Specific Relief Act is discretionary and the court has to pass an order as the justice may require. In the case of S. Murli Sundaram versus Jyotibai Kannan and others, it was held by Supreme Court, thereby reiterating that exercise of power of review under Order 47 Rule 1 of the Civil Procedure Court is limited, and under the guise of review, the petitioner could not be permitted to re-agitate and re-argue questions which had already been addressed and decided by the court earlier. Next is the case of Samarlal Agarwal and others versus Ashok Kumar Kothari and others, in which it was observed that execution courts must be conscious that they cannot draw a new decree as observed by Honorable Apex Court while setting aside the order of execution court. The next case is Panchamlal Pandey versus Neeraj Kumar Mishra and others, in which Honorable Apex Court held that the provision of review was not to scrutinize the correctness of the decision rendered, rather to correct the error if any. The next case is Gas Point Petroleum India Limited versus Rajendra Marothi. In this case, Honorable Supreme Court reiterated that non-compliance of the mandatory period provided under Order 21 Rule 84 and Order 21 Rule 85 had the effect of initiating the auction sale. Honorable Supreme Court was hearing an appeal filed against the impugned judgment of Honorable Madhya Pradesh Court, wherein the writ petition filed against the order of lower appellate court was allowed on the ground that the appellant had failed to plead and establish the nature of irregularity or fraud committed in sale, and therefore no fault could be found in the order of the executing court. The last case from the CPC would be Ananta Chandrakant Bhonsule, dead by Ellas and another, versus Trivikram Atmaram Korjoinkar, dead by Ellas and another, in which Honorable Supreme Court held that the ouster of jurisdiction of the civil court can be expressed or implied, but it cannot have a retrospective effect annulling a decree validly passed by the civil court. The court was dealing with an appeal challenging the judgment passed by the Bombay High Court, Goa, that confirmed the judgment and decrees of the trial and appellate court ordering the eviction of the appellant. Now a few cases from the constitutional law. The first would be Ashwani Kumar Upadhyay versus Union of India and others. In this case, Honorable Supreme Court dismissed a public interest litigation petition filed by BJP leader and advocate Ashwani Kumar Upadhyay seeking remaining of historical places and cities which he claimed are currently named after invaders. It was held by Honorable Supreme Court while dismissing the petition that the present and future of a country cannot remain a prisoner of the past. The governance of Bharat must conform to rule of law, secularism, constitutionalism, of which Article 14 stands out as the guarantee of both equality and fairness in states' action. The next case is Ramesh Chandra Sharma and others was a state of UP. In this case, while allowing the appeal by Honorable Supreme Court, it was held the classification made between Pushtani and Gair Pushtani landholders by the Allahabad High Court is violative of Article 14 of the Indian Constitution. In this case, writ petitions were filed by certain landowners whose land was acquired by Noida. Honorable Allahabad High Court had passed orders in favor of Noida. Another case is Suresh Kumar, Lalit Kumar Patel and others versus State of Gujarat. In this case, Honorable Supreme Court set aside the decision of Gujarat High Court and observed the Departmental Selection Committee decision to reduce the qualifying marks after the publication of results to facilitate the appointment of a special category of candidates comprising women, persons with disabilities and former members of the armed force to the post of Supervisor Instructor Class 3 in various industrial training institutes across the state of Gujarat is violative of Article 14. Next case is Association of Vasant Apartments Owners versus V. Gopinath and others. In this case, Honorable Supreme Court has upheld a rule which mandated the builders should reserve open spaces in the plots developed by them. The rule in question was Rule 19 of the Development Control Rules for the Chennai metropolitan area. The rule mandated that 10% of the area of any developmental plan having area 10,000 square meter or more should be reserved as open space for communal and recreational use, and that such open space area must be transferred to the local authority free of cost through a registered gift deed. So the Chennai Metropolitan Development Authority would be empowered to maintain the open space area. The bench rejected the pleas to declare Rule 19 as void. The bench held that Rule 19 did not violate Article 14 for being unreasonable or violate the right to property under Article 300A of the Constitution. The bench also rejected the argument that such compulsory reservation of open space in favor of the local authority will amount to acquisition of land. The next case is Haji Abdul Ghani Khan versus Union of India, in which Honorable Supreme Court observed that Article 170 of the Constitution deals only with the state legislature and thus no application to the legislatures of the union territories. Legislative assemblies of the concerned union territories will be governed by the law made by Parliament in accordance with Article 239A and not by the provision of Chapter 3 of Part 6. The court observed thus in its judgment dismissing a petition which challenged the delimitation exercise carried out for redrawing the Legislative Assembly and Lok Sabha constituencies in the Union Territory of Jammu and Kashmir. The next case is Anna Matthew versus Supreme Court of India. In this case, while dismissing the pleas challenging the appointment of Justice Lakshmana Chandra Victoria Gauri as additional judge of the Madras High Court, Honorable Supreme Court held that the question where a person is fit to be appointed as a judge involves suitability aspect and stands excluded from the purview of judicial review. While explaining the difference between the eligibility and the suitability, the court observed that when eligibility is put in question, the question would fall within the scope of judicial review. However, the question where the person is fit to be appointed as a judge essentially involves the aspect of suitability and stands excluded from the purview of judicial review. The next case is National Medical Association versus Anna Sahib Chudaman Patil Memorial Medical College, in which Supreme Court, while deciding the appeals imposed by penalty of rupees 2.5 crores on a medical college that was involved in illegal admission of the students in MBBS, the court also directed the college not to recover the amount of penalty from the students in any manner for the present year and thereafter. The next case is Bar Council of India versus Bonifoy Law College and another, in which the Constitution Bench of the Supreme Court held that the Bar Council of India has the power to prescribe the All India Bar examination for law graduates. The court overruled the case of V. Sudhir versus Bar Council of India, in which the Bar Council of India Training Rules 1995 was struck down by the Apex Court. The bench said that it must be left to the BCI as to what stage the AIBE has to be held, pre or post, and that the result of the AIBE would be subject to the person passing all the components required under the course of study of the university or college, would be subject to the AIBE result being valid for a specified period of time. The next case is Central Board of Dawoodi Bohra Community versus State of Maharashtra. In this case, Honorable Constitutional Bench of the Supreme Court referred an issue relating to the practice of excommunication in the Dawoodi Bohra community to a larger 9-judge bench, holding that such a practice is to be tested on the touchstone of the concept of constitutional morality. Honorable Supreme Court also considered the 1962 judgment of Sardar Sayadin Tahir Saifuddin Sahib versus the State of Bombay. The next case is Anushka Rengunthwar versus Union of India and others, in which Honorable Supreme Court upheld the notification issued by the central government in 2021, which took away the right of overseas citizens of India category students to apply for general seats and confined their rights only to NRI, that is non-resident Indians category seats, but with prospective effect. And the last case from the Constitution would be Ashwini Kumar Upadhyay versus Union of India and other, in which Honorable Supreme Court dismissed the petition wherein it was sought to restrict people from contesting election from the same office from two constituencies simultaneously, thereby holding that this is legislative policy and it is for the Parliament to decide. A few cases from Consumer Protection Act 1986. The first case is Aman Semiconductors Private Limited versus Haryana State Industrial Development Corporation Limited and another. In this case, Honorable Supreme Court upheld the decision of NCDRC and observed that the idea behind the development of the industrial plots and allotting them to deserving applicants was to act as a catalyst to promote economic growth. In this case, despite allotment and letter of intent to the appellant to the industrial plot, along with the final payment made in respect of the plot, as well as an agreement was executed between HSIDC and the appellant in which he agreed to complete the project in 2 years. The appellant took possession of the plot, but construction could not be completed within the time stipulated. On issuance of the notice, he replied that he could not start the unit due to lack of infrastructural facilities. The HSIDC later resumed the plot and cancelled the allotment. The appellant approached the district forum and allowed the complaint and directed the HSIDC to withdraw the resumption order. HSIDC appealed before the State Commission, which also rejected. It then approached NCDRC, which also rejected the appeal as it was filed belatedly. However, HSDIC approached the Apex Court, which reverted back the matter to NCDRC to hear on its merits. The NCDRC allowed the revision petition, aggrieved of which the appellant approached the Apex Court. Another case is Karnavati Veneers Private Limited versus New India Assurance Company Limited and others, in which the court set aside the impugned judgment of National Consumer Dispute Redressal Commission and directed the respondent insurance company to pay rupees 21,76,524 to the insured as assessed by the surveyor. Another case is Debasi Sinha and others versus Mrs. R&R Enterprise represented by its proprietor or chairman, Kolkata and others, in which Honorable Supreme Court held that a long delay in passing the order has its own effect and hence directed NCDRC to decide on a consumer complaint preferably within 1 year. The court was dealing with an appeal filed under Section 23 of Consumer Protection Act by the aggrieved flat owners against an order passed by the NCDRC wherein the appellant's complaint was dismissed. It was held that flat owners do not forfeit the right to claim amenities promised by the developer by taking possession of the apartment. The last case from Consumer Protection Act would be ITC Limited versus Ashna Roy. In this case, Honorable Supreme Court set aside NCDRC order of awarding rupees 2 crore compensation to a model for a faulty haircut at a hotel saloon in 2018. Honorable Supreme Court observed that while quantifying the amount of compensation, no reference or discussion on any matter evidence was made by NCDRC and had set aside the order of NCDRC where compensation of rupees 2 crore was awarded to the respondent for loss of income, mental breakdown and trauma due to deficiency in service and damage caused to her hair. One case from Contracted Act 1872, that is National Insurance Company Limited versus the Chief Electoral Officers and others, in which the court, while allowing an appeal filed by National Insurance Company Limited, held that the cause arising from sunstroke cannot be included in the parameters of scope of cover in the insurance policy, defining when such insurance amount would become payable. The court was dealing with a matter in which the order passed by Honorable Patna High Court was challenged by the insurance company. A number of cases from Criminal Procedure Code 1973. The first case is Royden Bhairol Butelo versus State of Chhattisgarh. In this case, it was held by Honorable Supreme Court that the power to transfer the investigation is an extraordinary power and it is to be used very sparingly and in an exceptional circumstance where the court, on appreciating the facts and circumstance, arrives at the conclusion that there is no option of securing a fair trial without the intervention and investigation by the CBI or such other specialized investigating agency which has the expertise. The next case is Roopwanti versus State of Haryana and others, in which, in an appeal against the decision of Honorable Punjab and Haryana High Court, which had acquitted the respondent accused under sections 148, 149, 323, 324, 307, 302, 506 of IPC, it was noted by Honorable Supreme Court that where a reversal of acquittal is sought, the courts must keep in mind that the presumption of innocence in favor of the accused on grounds of it surviving the rigors of full trial is strengthened and stands forfeited. Therefore, the prosecution, while still working under the same burden of proof, is required to discharge a more onerous responsibility to annul and reverse such presumption of innocence. The next case is Anant Thanur Karmuse versus the state of Maharashtra, in which it was held by Honorable Apex Court. The mere filing of the charge sheet and framing of the charges cannot be an impediment in ordering further investigation or reinvestigation or de novo investigation. If the facts so warrant, the victim has a fundamental right of fair investigation and fair trial. Another case is the Directorate of Enforcement versus M. Gopal Reddy and another, in which Honorable Supreme Court reiterated that the conditions under Section 45 of the Prevention of Money Laundering Act for grant of bail are applicable to anticipatory bail applications under Section 438 of the Code of Criminal Procedure as well. Observations were made while setting aside an order of the Honorable Telangana High Court, which observed that rigors of Section 45 PMLA are not applicable to anticipatory bail applications. Another case is Juru versus Kareem, in which it was held by Honorable Supreme Court that the power of summoning under Section 319 CRPC is not to be exercised routinely, and the existence of more than a prima facie case is necessary to summon an additional accused. Guideline laid down by the Constitutional Bench of Honorable Supreme Court in the case of Sukhpal Singh Khera versus State of Punjab was reiterated for the trial courts to follow. The next case is Rana Ayub versus Directorate of Enforcement through its Assistant Director. In this case, Honorable Supreme Court, while dismissing the plea of Rana Ayub, said that the issue of territorial jurisdiction cannot be decided in a writ petition, especially when there is a serious dispute regarding the place of commission of the offence. Honorable Supreme Court was dealing with a matter in which the petitioner challenged the jurisdiction of the Special Court Ghaziabad under the Prevention of Money Laundering Act 2002 to take cognizance of the complaint filed by the Enforcement Directorate against her for the violation in amounts collected through the crowdfunding for the COVID relief. The next case is Chandmal alias Chandanmal versus the state of Madhya Pradesh and another. In this case, Supreme Court expressed its anguish at trial courts acting in violation of its judgment in Siddharth versus state of Uttar Pradesh and Satyendra Kumar Antal versus Central Bureau of Investigation. It was observed by Honorable Supreme Court that we failed to understand why, despite these judgments having been circulated, some of the trial courts are conducting and passing the orders in teeth of these judgments. It is a matter of concern that these cases thus keep on coming to the apex court unnecessarily. Virtual hearing, we would normally expect that even in the district courts in the COVID period, arrangements would have been made for virtual hearing. It is not as if the virtual method of appearing before the court has to be abandoned, as this is an alternative method of appearance now, which is to be followed by different courts. The judgment on in re policy for strategy of bail was circulated by our High Court, that is Honorable Punjab and Haryana. The order passed was 31st of January 2023, in which following directions were issued by Honorable Supreme Court pertaining to the bail matter. The court which grants bail to an under trial prisoner or convict would be required to send a soft copy of the bail order by email to the prisoner through the jail superintendent on the same day or the next day. The jail superintendent would be required to enter the date of grant of bail in the e-prison software or any other software which is being used by the prison department. If the accused is not released within the period of 7 days from the date of grant of bail, it would be the duty of the superintendent or jail to inform the secretary DLSA, who may depute paralegal volunteer or jail visiting advocate to interact with the prisoner and assist the prisoner in all ways possible for his release. NIC would make attempts to create necessary fields in the e-prison software so that the date of the grant of bail and date of release are entered by the prison department, and in case the prisoner is not released within 7 days, then an automatic email can be sent to the Secretary DLSA. The Secretary DLSA, with a view to find out the economic condition of the accused, may take a help of the probation officers or the paralegal volunteers to prepare a report on the socio-economic condition of the inmate, which may be placed before the concerned court with a request to relax the conditions of bail or surety. In case where the under trial or convict requests that he cannot furnish bail bonds or sureties once released, then in an appropriate case, the court may consider granting temporary bail for a specified period to the accused so that he can furnish bail bond or surety bonds. If the bail bonds are not furnished within 1 month from the date of grant of bail, the concerned court may suo motu take up the case and consider whether condition of bail require modification or relaxation. One of the reasons which delays the release of the accused or convict is the insistence upon the local surety. It is suggested in such case the courts may not impose the condition of local surety. The last case from the Code of Criminal Procedure is State of Haryana versus Darshan Singh and another. In this case, Honorable's Apex Court issued notice to the State of Punjab, returnable in 4 weeks, limited to the question of certain observation made in the judgment with respect to the applicability of Section 82, subsection 1 of Criminal Procedure Code and its effect only to persons accused of certain offences. In the meanwhile, the directions to circulate judgment to the concerned, such as District Session Judge via state, shall remain state. Another case is from Hindu Marriage Act 1956, that is Seema Kaushal versus Dheeraj Kumar. In this case, the court refused to transfer the divorce petition from Jaipur to a remote place like Kurukshetra in Haryana, as it was inconvenient to both parties. The court observed that when both the parties to the marriage or divorce petition are residing in Jaipur, it is not just and proper to transfer the case outside Rajasthan to a remote place like Kurukshetra in Haryana. The court added that it will not be convenient to both of them as well. While on duty, they will have to go to attend the proceedings to such a long distance and return. A few cases from Indian Evidence Act 1872. The first is Aparna Ajinkya Firodia versus Ajinkya Arun Firodia. In this case, it was observed by Honorable Supreme Court that the DNA test of children born during a valid marriage may be directed only when there is sufficient prima facie material to dislodge the presumption under Section 112 of the Evidence Act. In that context, the court observed that the children have the right not to have their legitimacy questioned frivolously before the court of law. This is an essential attribute to the right of privacy. Courts are therefore required to acknowledge that children are not to be regarded as material objects and be subjected to forensic DNA or testing, particularly when they are not parties to the divorce proceeding. It is imperative that children do not become the focal point of the battle between spouses. The next case is Ram Gopal, son of Mansha Ram versus State of Madhya Pradesh. In this judgment rendered by Honorable Supreme Court, important observation was made on the application of last seen theory in murder case. Upholding the conviction of an accused in a murder case, Honorable Supreme Court explained that once the prosecution has shown that the victim was last seen together along with the accused, then the accused has to give explanation. Once the theory of last seen together was established by the prosecution, the accused was expected to offer some explanation as to when and under what circumstances he had parted the company of the deceased. The next case is Kashibai versus State of Karnataka. In this case, the ingredients of the offences under Section 306 and 107 IPC were reiterated. It was held that in order to convict a person for the offences under Section 306 IPC, the basic constituent of the offence, namely where the death was suicidal and where there was an abetment on the part of the accused as contemplated in Section 107 IPC, have to be established. In order to bring the case within the purview of abetment under Section 107 IPC, there has to be an evidence with regard to the instigation, conspiracy or intentional aid on the part of the accused. For the purpose of proving the charge under Section 306 IPC, also there has to be an evidence With regard to the positive act on the part of the accused to instigate or aid to drive a person to commit suicide, reference was made of M. Mohan versus State, represented by the Deputy Superintendent of Police. Mere fact of commission of suicide by itself would not be sufficient for the court to raise the presumption under section 113A of the Indian Evidence Act and to hold the accused guilty of section 306 IPC. Cases from Indian Penal Code 1860. The first case is Inderjit Das versus State of Tripura. In this case, Honorable Apex Court reiterated the principles qua circumstantial evidence, thereby relying upon Sailendra Rajdev Paswan and others versus State of Gujarat and Sarad Bidhichand Sharda versus State of Maharashtra. It was observed that the basic links in the chain of circumstances starts with motive and then move on to last scene theory, recovery, medical evidence, expert opinion, if any, and any other additional link which may be a part of the chain of circumstances. In a case of circumstantial evidence, motive has an important role to play. Motive may also have a role to play even in a case of direct evidence, but it carries much greater importance in a case of circumstantial evidence than a case of direct evidence. It is an important link in the chain of circumstances. Accordingly, Honorable Supreme Court reversed a conviction recorded by the trial court, affirmed by Honorable Tripura High Court on the ground that the major links of the chain of circumstances had not been proved by the prosecution evidence in a case based on the circumstantial evidence. The next case is the state of Madhya Pradesh versus Juvenile. In this case, the trial court convicted the respondent Juvenile, original accused number 3, for the offences punishable under section 302 with the aid of section 34 IPC. By the impugned judgment and order, Honorable High Court had acquitted the respondent accused number 3 by observing and holding that the prosecution had failed to prove the case of common intention. State preferred the appeal. While allowing the appeal, it was observed by Honorable Supreme Court on the appreciation of the evidence that the respondent participated actively in the commission of the offence and shared the common intention to kill the accused. Reference was made to State of Rajasthan versus Gurcharan Singh and others. The next case is Vaheta versus State of Tamil Nadu. In this case, Honorable Supreme Court held that the entire prosecution cannot be disbelieved and discarded simply because one police witness did not project the case in a consistent manner. In this case, an appeal was preferred against an order which held the appellant guilty of the offence punishable under section 302 IPC, awarding her the punishment of imprisonment for life. The appellant had been convicted of the murder of her 5-year-old child in her mother-in-law's house. The next case is Ajay alias Ajju etc. versus State of Uttar Pradesh. In this case, Honorable Supreme Court affirmed sentence and conviction of accused for murder based on solitary eyewitness testimony. It was reiterated that it is not the quantity of the witnesses but the quality of the witness which matters. It was observed that non-examination of the statement under section 164 CRPC also has no relevance or bearing to the findings and conclusions arrived at by the courts below. It was for the investigating officer to have got statement under section 164 CRPC recorded. If he did not think it was necessary in his wisdom, it cannot have any bearing on the testimony of PW1 and other material evidence during trial. The next case is Suresh versus State of Kerala. In this case, the Honorable Apex Court held that the appellant accused had been rightly convicted under section 302 of the Indian Penal Code by the trial court as the accused had committed the murder in a premeditated manner. In this case, an appeal was preferred against the order of Honorable Kerala High Court, wherein the conviction of the appellant accused under section 302 and 449 of the IPC was upheld and was sentenced to imprisonment for life. On perusal of the medical evidence by the court, it was noted that the post-mortem report revealed that heavy grinding stone was used for the commission of the offence and the pressure was applied while injuries were inflicted over the vital parts of the body of the victim. The last case from the IPC would be P. Sivakumar and others versus State, represented by Deputy Commissioner of Police, etc., in which Honorable Supreme Court, while allowing the appeals, held that the conviction under Section 498A of the IPC is not sustainable when the marriage is found to be null and void. Honorable Supreme Court relied upon the judgment in the case of Shiv Charan Lal Verma versus State of Madhya Pradesh in this matter. Certain directions were issued by Honorable Punjab and Haryana High Court, which were circulated also by judgment Suraj versus State of Haryana in the matter pertaining to Juvenile Justice Care and Protection of Children Act 2015. The directions are as follows. With regard to the dealing of the claim of the juvenility, as and when any person brought before the court, including an appellate court, who is alleged to have committed an offence, claims before that court that he is a child or was a child on the day of commission, the said court shall promptly conduct an inquiry to determine the age of that person under subsection 2 of section 9. The courts and the authorities are required to deal with children differently from adults while dealing with children. Principle of presumption of innocence, principle of participation, principle of best interest, principle of non-stigmatizing semantics, principle of non-waiver of rights, and principle of natural justice as contained in section 3 of the Act of 2015 are required to be followed. The judicial officers and the authorities dealing with the children are required to be proactive during the process of age determination. The evidence regarding the age can be sought from the authorities wherever such evidence is available. The documents mentioned in section 94 subsection 2 of the Act of 2015 should be taken into consideration, and the process to determine the age as mentioned therein should be quickly followed. The parents or the guardians having the actual charge of the child should be joined during the proceedings in respect of a child by the authorities, child welfare committees, juvenile justice board, and by any court in compliance of the provision of section 90 of the Act of 2015. The judicial magistrate in charge of the juvenile justice board either individually or may accompany the district and session judge during the jail inspections and conduct regular inspection of the jail meant for adults to check if any child is lodged in such jails and take immediate measures for transfer of that child to an observation home or place of safety, as the case may be, as per the provisions of section 8M of the Act of 2015. The authorities and the courts dealing with children are required to allow the timelines given under the Act of 2015 and the model rules. The Juvenile Justice Board is required to complete the inquiry under section 14 subsection 1 of the Act of 2015 within a maximum period of 4 months, unless extended for a period of maximum 2 more months after recording the reasons for the said extension. The preliminary assessment in the case of a heinous offence is to be disposed of by the Juvenile Justice Board within the period of 3 months from the date of its production of the child before the board. The Chief Judicial Magistrate or the Chief Metropolitan Magistrate may grant extension of time for the completion of the inquiry by the Juvenile Justice Board for serious or heinous offences after recording the reasons as per proviso to subsection 4 of section 14 of the Act of 2015. The probation officers, the child welfare officers, and the social workers shall make an endeavour to submit social investigation report within a period of 15 days from the date of first production of the child before the Juvenile Justice Board as required under section 8 subsection 3 clause E of the Act of 2015. The process of age determination test under section 94 subsection 2 of the Act of 2015 be completed by the medical authorities within 15 days. The copy of an adverse order made by the Child Welfare Committee or by the Juvenile Justice Board under the Act of 2015 as well as copy of an adverse order passed by the Juvenile Justice Board after conducting preliminary assessment into a heinous offence under section 15 of the Act of 2015 shall be supplied to the person aggrieved of such an order free of cost, and the person aggrieved by such an order shall be informed of his right to appeal under section 101 of the Act. The Chief Judicial Magistrate or the Chief Metropolitan Magistrate shall review the pendency of the cases of the board in each district at least once in every 3 months. The Chief Judicial Magistrate or the Chief Metropolitan Magistrate shall place a report before the District and Sessions Judge regarding the review of the pendency of cases before the Juvenile Justice Board, and the cases in which the timeline provided under the Act of 2015 is not being adhered to. The District and Sessions Judge would scrutinize the reason for increase in pendency, if any, and the reason for not adhering to the timeline provided under the Act, and would discuss such reasons and to find out the solution during the periodical district level meeting which are being held or to be held for the implementation of Act of 2015. The registry was directed to circulate the copy of the judgment to all the judicial officers with the direction to adhere to the aforesaid directions. Next few cases from Land Acquisition Act and Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013. The first is Ravindra Kumar Goyal versus State of Haryana, in which Honorable Supreme Court had set aside Honorable Punjab and Haryana High Court judgment reducing market rate value in respect of the lands acquired for the construction to express highway. Honorable Apex Court observed that when the parties were before the court in its first round of litigation, the court, without relying upon the circular fixing floors rates, demanded the matter to the reference court for fresh consideration. Honorable Apex Court noted that despite this, the High Court merely relied on the circular providing for the floor rates despite other evidence being available on record. The state of Madhya Pradesh versus Subhash Chandra. In this case, Honorable Supreme Court reiterated that an enhancement given between 8% to 15% is permissible as per its catena of decisions, and in case has modified the order of the High Court from a 12% enhancement to a 10%. In 2010, a large chunk of land came to be acquired by the state of Haryana for public purpose under the provisions of the Land Acquisition Act 1894. The land acquisition officer declared the award at a rate of rupees 60 lakh per acre. Later, the reference court enhanced the compensation to rupees 1 crore 56 lakh 24,000 per acre from rupees 60 lakhs per acre when a reference under section 18 was made at the instance of the original landowners. The state preferred appeal against the award passed by the reference court were dismissed by the High Court. Also, the High Court partly allowed the appeals preferred by the landowners and awarded the compensation at rupees 2 crore 98 lakh 54,720 per acre. The next case is from Haryana State Industrial Infrastructure Development Corporation versus Satpal, in which the Honorable Supreme Court, while dealing with the appeals filed by Haryana State Industrial Infrastructure Development Corporation, held that the sale deed after the first notification is not a basis for determining compensation for subsequent acquisition. The appeal challenged the judgment passed by Honorable Punjab and Haryana High Court, in which the compensation of the land acquisition was enhanced to rupees 29 lakh 54,000 and rupees 45 lakh per acre for the villages. Judgments from the Motor Vehicle Act 1988. The first one is Chaus Toshif Almia etc. versus Memon Muhammad Umar Anwar Bhai and others, in which Honorable Supreme Court, in an appeal relating to a motor accident claim, has held that the award for compensation cannot be based on any mathematical formula but has to be commensurate to the nature of suffering and pain, its extent, length and duration. In this case, the appellant, while traveling together in the same vehicle, met with an accident resulting in the severe injuries to both. The tribunal awarded compensation, but being aggrieved with the amount, the appellants moved to the High Court and their appeals were partly allowed. Hence, the appellant approached the Honorable Supreme Court, being satisfied with the High Court decision. The judgment of Gohar Mohammed versus State of Uttar Pradesh Road Transport Corporation and others was circulated by Honorable Punjab and Haryana High Court as passed by Honorable Supreme Court on 15th of December 2022, wherein following directions were issued relating to motor vehicle accident claims. The appeal filed by the owner challenging the issue of liability is hereby dismissed, confirming the order passed by the High Court and MACT. On receiving the intimation regarding road accident by use of a motor vehicle at the public place, the SHO concerned shall take steps as per section 159 of the MV Amendment Act. After registration of the FIR, the investigating officer shall take recourse as specified in the MV Amendment Rules 2022 and submit the FAR within 48 hours to the Claims Tribunal. The IAR and DAR shall be filed before the Claims Tribunal within the time limit subject to the compliance of the provisions of the rule. The registering officer is duty bound to verify the registration of the vehicle, driving license, fitness of vehicle, permit and other ancillary issues and submit the report in coordination to the police officer before the claims tribunal. The flow chart and all other documents as specified in the rules shall either be in vernacular language or in English language as the case may be and shall be supplied as per rules. The investigating officer shall inform the victims or legal representatives, drivers, owners, insurance company and other stakeholders with respect to the action taken following the MV amendment rules and shall take steps to produce the witnesses on the dates fixed by the tribunal. For the purpose to carry out the direction as given in point 3, that is C here, distribution of police or station attaching them with the claim tribunal is required. Therefore, distribution memo attaching the police station to the claim tribunal shall be issued by the Registrar General of the High Court from time to time, if not already issued, to ensure the compliance of the rules. In view of the MV Amendment Act and rules are discussed here and above, the role of the investigating officer is very important. He is required to comply with the provisions of the rules within the time limit as prescribed therein. Therefore, for effective implementation of the MV Amendment Act and the rules framed thereunder, the specified trained police personnel are required to be deputed to deal with the motor accident claim cases. Therefore, we direct that the Chief Secretary Director General of Police in each and every state or union territory shall develop a specialized unit in every police station or at town level and post the trained police personnel to ensure the compliance of the provisions of the MV Amendment Act and rules within the period of 3 months from the date of this order. On receiving FAR from the police station, the claim tribunal shall register such FAR as miscellaneous application. On filing the IAR and DAR by the investigating officer in connection with the said FAR, it shall be attached with the same miscellaneous application. The claim tribunal shall pass its appropriate order in the said application to carry out the purpose of section 149 of the MV Act Amendment Act and the rules as discussed above. The claim tribunal are directed to satisfy themselves with the offer of a designated officer of the insurance company with an intent to award just and reasonable compensation. After recording such satisfaction and the settlement be recorded under section 149 subsection 2 of the MV Amendment Act, subject to consent by the claimant. If the claimant is not ready to accept the same, the date be fixed for hearing and affording an opportunity to produce the document and other evidence seeking enhancement, the petition be decided. In the said event, the said inquiry shall be limited only to the extent of the enhancement of compensation, shifting onus on the claimant. The General Insurance Council and all insurance companies are directed to issue appropriate directions to follow the mandate of section 149 of the MV Amendment Act and the amended rules. The appointment of the nodal officers prescribed in Rule 24 and the designated officer prescribed in Rule 23 shall be immediately notified, and modified orders be also notified from time to time to all the police stations or stakeholders. If the files an application under section 164 or 166 of the MV Amendment Act on receiving the information, the miscellaneous application registered under section 149 shall be sent to the claim tribunal, where the application under section 164 or 166 is pending immediately by the claims tribunal. In case the claimants or legal representatives of the deceased have filed separate claim petitions in the territorial jurisdiction of a different high court, in the said situation, the first claim petition filed by the claimant or legal representative shall be maintained by the said claim tribunal, and the subsequent claim petition shall be transferred to the claim tribunal where the first claim petition was filed and pending. It is made clear that the claimants are not required to apply before this court seeking the transfer of other petitions, though filed in the territorial jurisdiction of different high courts. The Registrar General of the High Court shall take appropriate steps and pass appropriate order in this regard in furtherance to the direction of this court. If the claimants take recourse under section 164 or 166 of the MV Amendment Act, as the case may be, he or they are directed to join nodal officer or designated officer of the insurance company as respondents in the claim petition as proper party of the place of incident where the FIR has been registered by the police station. Those officers may facilitate the claims tribunal specifying the recourse taken under section 149 of the MV Amendment Act. Registrar General of the High Court, States Legal Service Authority and State Judicial Academies are requested to sensitize all the stakeholders as early as possible with respect to the provisions of the chapters 11 and 12 of the MV Amendment Act and the MV Amendment Rules 2022 and to ensure the mandate of law. For compliance of mandate of Rule 30 of the MV Amendment Rules 2022, it is directed that on disputing the liability of the insurance company, the claim tribunal shall record the evidence to local commissioner and the fee and expense of such local commissioner shall be borne by the insurance company. The state authorities shall take appropriate steps to develop a joint web portal or platform to coordinate and facilitate the stakeholders for the purpose to carry out the provisions of MV Amendment Act and the rules in coordination with any technical agency and be notified to public at large. Now, two of the judgments from Negotiable Instrument Act. The first one is Yogesh Upadhyay and another versus Atlanta Limited. In this case, Honorable Supreme Court held that its power to transfer criminal cases under Section 406 of the Code of Criminal Procedure remains intact in relation to the offences under Section 138 of the NI Act, if it is found expedient for the ends of justice. In this case, the court was dealing with the two transfer petitions filed under Section 406 CRPC by the petitioners seeking transfer of the case pending before the Civil Judge Senior Division Nagpur to the Southwest District Courts Dwarka, New Delhi. Another case is Mita India Private Limited versus Mahindra Jain. In this case, general power of attorney was executed on behalf of the company in favor of one of its director named Kavinder Singh Anand, who further authorized another person, Ripanjit Singh Kohli, to file a complaint under Section 138 of the NI Act on behalf of the company. The Madhya Pradesh High Court quashed the complaint under Section 482 of CRPC as the same was not maintainable on the ground that the complaint was not filed by the person authorized as he had no power to subdelegate. It was held and observed by Honorable Supreme Court that the said power of attorney do provide for the subdelegation of the function of the general power of attorney holders, and thus the filing of the complaint on behalf of the appellant company through its authorized representative Ripanjit Singh Kohli is not at all illegal or bad in law. Accordingly, Honorable Supreme Court set aside the order passed by Honorable Madhya Pradesh High Court while allowing the appeal. From the Protection of Women from the Domestic Violence Act 2005, that is Bhavna versus Bhera, in which Honorable Supreme Court held that in a complaint filed under the Protection of Women from Domestic Violence Act 2005, it is not open to the court to impose such onerous conditions upon the appellant who claims to be a victim of domestic violence. A few cases from service jurisprudence. First is Imtiaz Ahmed Malla versus State of Jammu and Kashmir. In this case, appointment order of the petitioner as constable of police cancelled as it was found that the petitioner was involved in a criminal case and was under arrest for 4 days and he consciously concealed the said information. It was held by Honorable Supreme Court that mere acquittal does not entitle an employee to the reinstatement in service. If a person is acquitted or discharged, it cannot obviously be inferred that he was falsely involved or he had no criminal antecedents. Director General, being the highest functionary in the police hierarchy, was the best judge to consider the suitability of the petitioner for induction into the police force. Another case is Bharti-ben Chandrakanta-bai Thakur versus State of Gujarat. It was the case of the appellant that she was appointed as an auxiliary nurse midwife in the year 1980 and had submitted her resignation in April 1993 but withdrew it in November 1993. The order accepting the resignation was passed much thereafter in December 1994. The order was set aside by the High Court and directed that the appellant was entitled to all consequential benefits. However, the division bench of letters patent appeal modified the order of the single bench to the extent that the appellant was held not to be entitled to any benefit for the period for which the resignation was in force. Honorable Apex Court observed the expression for the period for which the resignation was in force could not be stretched to a date after the resignation had been withdrawn in November 1993 before it came into force. Accordingly, the appeal was allowed and the state was directed to pay the arrears of pension to the appellant within the period of 1 month thereafter together with the rate of interest of 6% per annum. The next case is R.K. Jimanta Devi versus High Court of Manipur. In this case, it was held by Honorable Apex Court that failure to accord sufficient time for an employee to challenge the assessment of their performance for a particular year in an annual confidential report before a departmental promotion committee is convened would be treated as a non-disclosure of the evaluation report while setting aside the proceedings of a DPC of the Manipur High Court determining appointment to the post of Assistant Registrar. Next case is C. Yamini and others versus the High Court for the state of Andhra Pradesh at Amravati and another. In this, Honorable Supreme Court dismissed the petition filed by the 9 judicial officers from Andhra Pradesh for consideration for elevation as High Court judges. It was held that their service as ad hoc judges cannot be reckoned for the purpose of Article 217, Clause 2, Subclause A. Another case is the state of Gujarat and others versus HB Kapadia Education Trust. In this case, it was held by the court that granting aid court any school receiving grants from the government would not be eligible to receive said grants toward the expenditure of those teachers that are employed beyond the age bar stipulated by the court. The next case is National Technical Research Organization and others versus Dipti Diodhare. In this case, Honorable Apex Court, while allowing an appeal filed by the National Technical Research Organization, dismissed the order passed by the Karnataka High Court, wherein it granted the consequential benefit to the employee of the Defence Research Development Organization, including the benefit of past service that she had rendered for computing her terminal benefits. The next case is State of UP versus Srimati Priyanka, in which Honorable Supreme Court depreciated the state for filing cases and denying the benefit of benevolent schemes such as death-cum-retirement gratuity to the heirs of the deceased, and further imposed a cost of Rs 50,000 on the state to be paid to the heirs of the deceased. In this case, the deceased employee was working as a lecturer in 2001 and died while in service in 2009. The original writ petitioner, wife of the deceased, applied for the payment of gratuity due to her husband, but the same was rejected on the ground that the husband of the petitioner, while in service, had not opted for retirement at the age of 60 years. The next case is Vibhuti Shankar Pandey versus the state of Madhya Pradesh and others, in which Honorable Supreme Court upheld the decision of the division bench of Madhya Pradesh High Court and observed that a daily rated employee could seek regularization only if he had been appointed by a competent authority and had been working for a sanctioned post. In this case, the appeal was preferred against the order of the division bench of Honorable Madhya Pradesh High Court, wherein the single judge decision was set aside. The single judge had allowed the writ petition preferred by the appellant and had directed the regularization of the appellant from the date on which the juniors were regularized. Therefore, letters patent appeal was preferred before the division bench of the High Court by the state government, when it was held that the appellant's employment could not be regularized because his initial appointment did not satisfy the principle laid down by Honorable Supreme Court in the Uma Devi case. Last case from the service jurisprudence would be Maharashtra State Financial Corporation Ex-Employees Association and others versus state of Maharashtra, in which Honorable Supreme Court held that the employees who retired under the voluntary retirement scheme cannot claim parity with others who retired upon achieving the age of superannuation for the purpose of the pay revision. One case from Specific Relief Act 1963, that is Beni Prasad dead through Ellas versus Durga Devi. In this case, a civil suit was instituted by the respondent, that is the plaintiff, for possession of land by the demolition of the structure put up thereon and for permanent prohibitory injunction, restraining the defendant, that is the appellant, from interfering or on disputed land and another land appertinent to it owned by her. The suit was decreed in favor of the respondent or plaintiff, holding her as the owner of the encroached land and handing over the same after the demolition of the structures put up there was ordered. Against the order, appeal was preferred by the appellant defendant before the First Appellate Court. Based on the principle of acquiescence, the First Appellate Court modified the judgment, holding that the respondent plaintiff was not entitled to recover possession of the land and awarded her the compensation, and held that she was entitled to recover interest at the rate of 12% per annum from the date of filing of the suit till realization. Second appeal was filed by the respondent, whereby the judgment of the First Appellate Court was set aside and the decree of the trial court was restored. Against the order of second appeal, the appeal was preferred before the Honorable Apex Court. Honorable Apex Court held the mere delay in instituting a suit for recovery of possession, especially when it was filed well within the period of limitation prescribed, the doctrine of laches and acquiescence had no place to defeat the right of the plaintiff to obtain the relief on his establishing his title. So these are all about the important judgments for the month of February 2023. Until we meet next again with a few more judgments or some other topic. Namaskar.